Hi, Steve Hansen with Hansen IP Law. Hey, I want to talk to you about what has to be one of the biggest, most widely held misconceptions I've ever seen in patent law, and it concerns provisional patent applications. There is this widely held belief that you can file a thin or quick and dirty provisional patent application and get the benefit of that application by being able to rely on its filing date when it comes to determining what items are or are not prior art. And this conception is completely wrong. If there's one thing I want you to take away from this video, it is that a provisional patent application is only as good as what it actually discloses. Let's say that again. A provisional patent application is only as good as what it actually discloses. Now, a provisional patent application allows you to file a patent application in an informal manner. It doesn't have to have claims or formal drawings or the specification format that a regular non-provisional application has to have. And you file the application. It's never examined. It just sits in the patent office for a year, and then after the year's up, you have to file a non-provisional patent application if you want to claim the benefit of that provisional's filing date. Now, when this all becomes important is if prior art surfaces that has an effective date, like a publication date, that is between the day you file the provisional and the day you file the non-provisional, then the sufficiency of your provisional becomes important. And if the claims that you have in your non-provisional, and that's what the examiners look at, they look at the claims. If those claims rely on information that you did not include in your provisional, those claims will not be entitled to the provisional application's filing date, and it will be as if you had never filed the provisional in the first place. And that's the danger with provisional patent applications. They lead people to think that they can file almost any sketchy small disclosure, just a rough drawing in a paragraph. Sometimes I've even seen worse than that, and still get the benefit of that provisional application's filing date. And that is not the case. Now, the other thing you have to understand is that the sufficiency of a provisional a lot of times does not get addressed in the patent office by the patent examiners. They tend to look for prior art that comes before the non-provisional and the provisional, so they don't have to worry about looking at the sufficiency of the provisional application's disclosures. But I can assure you that when you get into litigation, if you ever try to enforce your non-provisional patent, you will likely face a challenge to the sufficiency of the provisional patent application, because a motivated defendant is going to look for prior art. And a lot of times they will find prior art with an effective date that is between your provisional application's filing date and your non-provisional application's filing date. And that, like I said, is the situation where the sufficiency of the provisional becomes very important. I mean, I had a client come to me once, and he had a picture of his invention with maybe one or two sentences, and it was filed as a provisional patent application by an invention disclosure company. I mean, one of these invention companies, that sometimes you see on late night TV that help inventors get patents. And honestly, he might as well have not bothered at all. The thing was completely useless. It would provide no benefit whatsoever. And he might as well have just waited till he could file a non-provisional patent application and forgotten about filing the provisional. Now, when you're in a time crunch, like if you have a trade show that comes up suddenly, or there's some sort of meeting where the inventors are going to have to disclose the invention, okay? Provisionals can be helpful because they give you a way to file something that helps you preserve your rights to the best degree possible. But it's not an ideal situation. I mean, you want to file as much as you can in a provisional patent application to ensure that any claims you're going to pursue later in your non-provisional will be fully supported. And so, my advice is generally put everything you can think of and have time to include in your provisional, and be as thorough as time and resources will allow. That's the way you get the best benefit out of the provisional. And there are some strategic benefits to filing provisionals. I'm not really talking about that. What I'm talking about here is this problem I see where there seems to be this misconception that, hey, I could just file a quick and dirty provisional, I'm protected. No, you may not be protected. And it's especially worse if when you file this thin provisional, if you go out and start talking to people about your invention and you talk to them about details that you didn't include in the provisional, then you have a real risk that they could run to the patent office with those new details, and you're not protected because you didn't include it in your provisional. Okay, so I know it's a little complicated because it involves the way the prior art works, but the one thing I want you to take away from this video is what I said at the outset, which is a provisional is only as good as what you actually disclose in it. Okay, I'm Steve Hansen. Till next time, take care.